this better? Okay, so we're gonna try this vertically. Hopefully this works out well. Okay, so let's start again. My name is Debbie, and I am the immigration attorney here at Elkhalil Law. I do a lot of family immigration here in the office. We see countless numbers of cases, and we've had so many questions regarding adjustment of status and consular processing for immigration. So what I'm going to do is do a broad overview of the two types of family immigration and basically kind of go down through the steps for each one. The first thing is I want to distinguish between adjustment of status and consular processing. Adjustment of status is when a qualifying relative or an immediate relative wants to apply for a family member, a spouse, children, parents, or brothers and sisters. So for adjustment of status, the one requirement or the main requirement for adjusting is that the beneficiary immigrant has to enter the country legally. That means that they had to have come into the country on legal status for them to adjust their status here. There are, of course, exceptions to the rule, such as if they entered prior to 2001 and they had an approved I-130 to 2001, that is one of the exceptions to adjusting your status here. However, that is not very common nowadays anymore. So most of the time for adjustment of status, we are adjusting here on a person that has entered legally, and immigration court is something for another topic or another day on another Facebook Live. But for these purposes for family immigration, adjustment is for immediate family relatives who entered legally. There are a couple of forms that I'm going to go over as well for adjustment. The first form is a petition. It is the initial petition that an immediate relative applies for their spouse, their kids, or brother, sister, or parent. The I-130 petition is essentially the first step in the immigration process. It's basically notifying USCIS that you do have a qualifying relative, and they now do a lot of vetting in this process. That means that before, an I-130 was only 2 pages, and you just need to notify USCIS of the two basic sets of info for both people, both persons, the petitioner and the beneficiary, and that's about it. So if you're applying for a spouse, for example, all you would need to show is that you had a wedding ceremony with a wedding marriage certificate, wedding photos, things like that. But now for the I-130 process, it is a much more complicated vetting process. So our packets for I-130 have changed drastically, and we put in a lot more detail and work into the initial I-130 process nowadays. But that is the first step. The second step is a bunch of forms that are actually combined together into one packet. Those forms are the I-485, which is the actual adjustment of status petition application. It also coincides or goes along with the I-765, which is the work authorization form. And the last one is the I-864, which is the affidavit of support form. If a person does not qualify enough or things like that, we may need to do an additional one for a co-sponsor, but that just completely depends on a case-by-case basis. And then the last form that is not generally put into this packet, but we generally do just for backup purposes, is the I-131 application for re-entry or emergency advance parole for anyone that might need to leave the country on an emergency basis during the whole process of the I-485. This process takes a little bit of time to go through. On a general basis, on a case that does not have any criminal records or any complications, this whole process of the I-130 and I-485 could take about a year, a little bit longer on average. So if you are sending the I-130 out on its own initially, That process takes about 5 to 6 months, and then you'll get the I-130 approval back, and then we send out the second phase for the adjustment of status. And the second phase for the adjustment of status generally takes about the same amount of time, and then you'll get an interview notice so that you and your spouse or your relative would go and interview at a local facility, which is a local USCIS facility. Here in Atlanta, we have one facility that takes all of our interviews, and each city has their own facility that coordinates with USCIS for that. But for the most part, these are the basic forms that are needed for an adjustment packet. Of course, it is on a case-by-case basis for each type of case, or whether it be a spouse or a child, minor, older, parent, or brother or sister. That is for something that we do on a case-by-case evaluation. That means that we look at all of the documents in detail, and then we go from there we basically try to customize the packet for each client. So that is something that we are really, really good about, and I oversee every single packet that leaves this office. There's multiple sets of eyes, so that's why we do these packets so regularly, and we have really good turnout and returns for these packets. I'm going to go over a little bit about the interview as well. A lot of people ask us about the interview because it's kind of an unknown thing. For more general cases for adjustment of status, a lot of times the interview can be really, really scary. And that's completely understandable because the immigration officer is trained to not put you at ease. They're trained to make sure that they get all of the answers out of you as quickly and concisely, but they want to make sure that all of the questions are validated as per the forms that they are seeing in front of them. So we are really, really careful about going over the packets with each client so that they know exactly what they have submitted onto the forms. And we also meet with the client beforehand, and they also get to review the forms with us as well. So that's a really important aspect of our firm, of how we treat our clients and make sure that they are comfortable and ready for that interview. On top of that, we also sometimes attend the interview with the client if they feel better about it. The attorney is not allowed to answer any of the questions unless it is to clarify a question, or if the USCIS officer actually addresses the attorney. But for a lot of our clients, they feel a lot more secure, and there's a sense of support behind them when we are present with them for the interview. So that is something that a lot of our clients really like as an additional service to our family packets. One of the other small things for adjustment of status is the medical examinations. We also have access to approved USCIS doctors that are nearby, and we also do it on a zip code basis. So USCIS does provide doctors that are qualified to do these medical examinations for USCIS, and these medical examinations need to be done prior to sending in the adjustment of status packets. So in addition to the list of required documents that we submit to the client for them to return to us, we also request that they get their medical examinations done, and to do it soon, very close in time to when we send out the packets, so that we have everything to be up to date and prepared and ready to go for when we send the mailing packets out. So that is kind of the whole broad basis for the adjustment of status. For the questions that are coming in, I'm seeing some of them right now, but it's a little bit hard as I'm scrolling through. But I'm going to address those questions closer to the end once I finish talking about the consular processing aspect of family immigration. And then I'm going to start addressing questions because we are collecting them and we are seeing them. Let's move on to the consular processing aspect. Consular processing is basically the very similar process to adjustment, except that the beneficiary will actually be interviewing overseas in their home country. So a lot of the family immigration cases that have spouses, brother, sister, parent, or children that are still in the home country, they would be consular processing. Another reason or another time that they would be consular processing is if they have entered illegally into the US but still qualify for a family immigration due to a qualifying relative, but because they entered EWI, which is without inspection, entry without inspection, they would need to consular process through their home country in order to get their green card or their legal permanent resident status. So those are the two ways that are generally used for consular processing. In the consular processing phases, the I-130 process is very, very similar to adjustment of status. It's almost identical, other than the fact that the beneficiary is overseas, and on that form we address which consular they will be interviewing at overseas. But for the rest of the information, it will be very, very similar. We are more careful in addressing the vetting process for the I-130 though, so I do recommend now, if you think the I-130 is a simple process and you're meticulous about your documents, it's something that you can do, you could, but for us, we have seen so many cases where people have done it on their own, and one tiny little minute detail can make all the difference, and so we definitely recommend that an attorney or an experienced attorney be used for the whole process. In addition, because you are consular processing and doing this abroad, it is a little bit easier because you already have an attorney that's designated for that case. And so when USCIS is talking to you, or when the case is approved and it moves forward towards the embassy, it is much better to have one attorney on record the whole way through, and they're walking you through that process from beginning until end. So that is another reason why we really recommend having one attorney of record to be the same if they're consistent and good from the beginning to the end. Anyways, so the I-130 process is pretty similar to adjustment, and once the I-130 is approved in about 5 or 6 months, we move forward towards the NVC, and that's what is called consular processing. Although it is similar to the adjustment of process on biographical information and main requirements, it is very, very similar. However, NVC, which is the National Visa Center, is adjusting everything over to a digital platform. Before, by sending in these packets, we did it very similarly to the adjustment of status packet. But now, because NVC is moving digital, we need to be a lot more careful about the things that we submit and how we submit them, so that we don't waste time. Every time that you submit something to NVC, it takes weeks to get back. They are trying to be better about it and answer the uploads and the submissions in a much more efficient manner, but in this transitioning process, it can still be very, very time consuming. It's a learning curve for both attorneys on our end as well as the NVC on the NVC's end and the embassy's end. So that's why we definitely want to be much more careful. Because we do this on a much more regular basis, we basically have a list of required documents, and we upgrade that list of required documents as per NVC's requirements. So if we're seeing things come through for the list of requirements that are requesting tax transcripts, before they used to request tax returns only, and then they would require W-2s or 1099s in addition. Well, now they're also requiring tax transcripts from both the petitioner as well as co-sponsor. Things like that are very time consuming to get. So if we know this in advance and we provide this in advance, it really, really helps the client in saving time on while they're gathering all these documents, and that makes them a lot more prepared for when they are ready to submit everything at once. So that kind of is a little tip for the consular processing aspect and on co-sponsors. But anyways, for the National Visa Center, it takes roughly around the same time for them to process each of these applications, and then from there it goes to the respective home countries of the beneficiaries. So for example, if we're going to an embassy in Baghdad or France, it would basically go to that home person's home country's embassy, and then the embassy will then schedule the interview as per the embassy's schedule deadlines or availability. Some embassies are much more efficient than other embassies, and that means it is very hard for us to send out timelines and processing times to our clients. The most that we can do is usually if we have clients going to the same country over and over and over, then yes, we kind of have a better idea about what the processing timeline is. But things change, the world dynamics always change, so therefore processing times for interviews also change. So once it gets to the embassy, the beneficiary has a choice. If it's for a marriage, a lot of times we ask if the other spouse that's in the US is going to be attending the interview with the beneficiary. Most of the time it is a very hard thing to do, because going overseas for a 2-week amount of time while the other spouse or petitioner is still working in the US, it can be very hard. It's not a deal breaker unless it is a case where they have not seen each other for a very long time and it's a marriage case. For the most part, the beneficiaries can go to the interview themselves, but we also try our best on our end here to prepare them for that interview as well. And that also means prepping them for the medical examinations that need to be done in their home country, not in the US. The beneficiary will doing the medical examinations through USCIS approved doctors. My apologies, it's through the Department of State's approved doctors, and that is given to them on a list of documents after they get the interview notice. So we kind of do an extra step and walk them through that process as well for medical examinations. Some countries also require us to register the interview notice. So if we get an interview notice online, some countries, for example, like Mexico, also require us to register that client online through the Department of State, and that's an extra step where additional password entries, re-entries of passport photos and things like that need to be done. We try to do that as much as possible so that our client is in the best position to go into that interview and we can oversee that aspect. So should something go wrong, or if there is an additional document that is needed and necessary, we would be able to upload that almost immediately after the interview process. So this is another feature of our service that is really, really important to a lot of our clients, because it is a very nerve-wracking process, and while they're going through this interview process, they can forget certain things because there's just so much going on at once. So that is a really, really nice feature to have. When it comes to the actual application for the NVC, I'm going to go over this. The reason I wanted to do the interview first is because it's nice, quick, and easy. But the DS-260 application itself for the NVC application is fairly complicated. And the reason I wanted to put some time and energy into explaining this process is because the DS-260 is not amendable. Once you submit something, that's it. That is what's going out, and then you send in supporting civil and financial documents for it. The financial and civil documents, if they don't have enough, they'll send you what is known as RFEs, and the RFEs will request, is essentially a request for additional information. So we really don't want to do that as much as possible. We want to be prepared in advance and submit everything out at once. And if there is an RFE, we're able to answer that as soon as possible and be prepared for it. We try to curb that by making sure that we ask all the correct questions fill out all questionnaires for us, and we gather as much documentation as possible before submitting the DS-260. Then once we go online and put in all of this information, a lot of times there's two sets of eyes that are going through this application in addition to the actual beneficiary and petitioner. That means the clients are going over this application in detail with us before we submit it. This is just a really, really important part about how you submit your application, and because this application kind of determines how long your processing places will be and how easy it will be to streamline this for an interviewing officer to review your application, it is a really, really important step. So that's why I emphasize this in detail about the DS-260. The last thing that I want to touch on is the visa bulletin. A lot of clients ask us about the visa bulletin because they're not really aware of how the visa process works. And a lot of clients that are waiting for a visa is not really sure how to read these charts as well. So for the visa bulletin, there are different categories of people that are applying for a visa. For example, a husband that applies for a spouse, his wife, has an immediate category. That means that that visa is immediately available. For the visa bulletin, it is for categories that are not immediately available. That means that there is a waiting line and a waiting list for visas to become available before that family member can be processed. And this is generally through legal permanent resident who are applying for their qualifying relatives, because legal permanent residents do not have current immediate status, and so their process for their beneficiaries take much longer. And because it takes much longer, the visa bulletin is a way for you to kind of track that process for the category that you are in. So I'm not going to go over all of the categories, but that's just kind of like a broad understanding of when an attorney tells you your visa is not available yet. That's where you would be checking, is the visa bulletin. So you can actually check that yourself, or you can inquire about your attorney, and we are happy to provide you with that bulletin. It is published every single month. So right now, I believe the August visa bulletin is already published, and it's very accessible online. You can Google visa bulletin, and Tabitha is going to link it into the box below so that you, if that's something that you need, we will have it there and linked for you. I think that is all that I need to go over as a general basis for family immigration. I think we've covered a lot of the points for adjustment of status as well as consular processing. I think let's start addressing some questions, and then I can go into more detail on certain things if there are any. But while we are waiting for the questions from Tabitha, I'm going to reiterate some of our information where you can gather a ton of resources that can help you in both family immigration, or if you have questions for anything else, because we post quite a bit. We have news roundups every week, we have updates, we have Instagram stories, we have posts, and of course Facebook Lives. So make sure that you check out all of those things and keep up to date with us, because we're always posting out a lot of information that can be really useful. Let me see. So our Facebook handle is at Elkhalil Law PC, and our Twitter and Instagram handles are they're the same. It is at Elkhalil Law, and our YouTube handle is Elkhalil Law, P.C. So Elkhalil.PC. That also goes for our LinkedIn handle. So if you want to search for any of those social media platforms, please feel free to reach out on any of those. And then, of course, direct contact is also much appreciated, and we welcome all of that as well. Direct emails, you can email us at info@elkhalillaw.com, and one of us will be happy to reach out to you. If you leave your name, phone number, brief synopsis of your case, and a contact info, we will be in touch with you within 24 to 48 hours max. The other way you can reach out to us is through our direct office line, which is 770-612-3499. And then our WhatsApp, which you can call us or text us from abroad because it is WhatsApp. It is 678-900-6845. All right. So, and one more thing, the website. Our website is a really great resource for us, and you have all of our contact info and social media platforms on there. Our website is www.elkhalillaw.com. All right. So one of the questions that came through, it is, my son was born in the USA when he was, and he has been in the US since he was 3 months old, and is it possible for him to get a green card for his parent? So I'm not quite sure I understand the question, actually. Your son was born in the US, so that means he is a US citizen. Is your son currently 3 months old? If he is 3 months old, then no, it is not possible for him to apply for his parent currently for his legal permanent resident status or his green card. For a child to apply for their parent, the child needs to be 21 years of age in order to apply for the I-130 through adjustment or consular processing for their parent. So I hope that answers your question, and you can reach out to us in any of the media platforms or contact info that I just provided if you want some more clarification on that. All right, I think there's a lot of traffic on CNN right now, so there's probably not a lot of questions yet, but don't worry. If you have questions that are coming through after this Facebook Live, please feel free to post it into the comments. We will see them and we will answer them. And of course, if you want to reach out to us directly on any of the social media platforms and direct contact info, please do so. We are happy to address any of your questions, and we look forward to hearing from you. Again, my name is Debbie, and I am the immigration attorney here at Elkhalil Law PC in Atlanta, and we look forward to hearing from you, and thank you so much for tuning in today. Have a good day.